as we kind of conclude this phase of our Mellon Foundation funded project. And we've been really lucky to have so many people contribute to this. I'm going to focus on the copyright section of this. If anyone, I doubt many have, but if anyone had looked at this in the last couple of weeks, you would have seen it was pretty bare bones. And I've been starting to build this out with materials as we go along. And over the next couple of months, as we finish up this grant and I get feedback on some information that I have, we will start to see more and more come about. So I'm sort of using, I admit, using this webinars as an excuse to force me to actually build out this website and make sure that all of these resources get to you all rather than being kind of stuck in a slide deck. So what I'm going to focus on today is the session that you all have come to see, which is evaluating rights as you're scanning and sharing. So this is very much focused not necessarily on the users of our materials in DLOC for publication or teaching or research, but focused more on the kind of earlier side of the process where we are all invested in deciding whether or not we can, in fact, even scan to begin with, whether or not we can share all those materials and how we might be able to do that. I will try not to stray too much into areas like copyright metadata that we'll talk about next week when we have our expert colleague Laura Perry here. But I will give kind of an overview of some of my thoughts on this and share a couple of resources that we're working on, and again, that we'll keep seeing develop over the next couple of months. So I want to emphasize that, because DLOC is based in the United States in terms of where it's technically hosted, where our content is hosted, we have over time really focused on copyright law in the United States. Certainly, as a US-based librarian, that's sort of the landscape that I've been coming from. But I have tried really hard over the last few years to flip that on its head a little bit, not necessarily saying that we aren't going to emphasize US law, which allows, for instance, for very flexible leveraging of fair use to make content available, but rather that we need to recognize as a 100+ partner community at this point that we're working with folks who are in a lot of different countries or jurisdictions within very different kinds of copyright kind of traditions over time. All of us are operating with a lot of similarity across all of our laws. There aren't radical differences between them, but in some cases that makes it almost harder. The devil's in the details, right? That we have slightly different lengths of copyright terms, or we have slightly different exceptions for teaching or for fair use or fair dealing, depending on what we call it. And so some of that is just continually coming together and trying to document some of those variations and how we actually want to grapple with them as a community. So what I'll focus on today, because I'm only speaking for a few minutes to you all, I want to highlight a couple of examples more than anything else, is kind of just this initial decision workflow. So I sat down and looked at a lot of different resources of what are the things that are really common threads, that even if some of these nuances are a tiny bit different, country to country, island to island, what are we really asking at our core? And so for me, one of the most important things that seems so obvious, but is actually really difficult, is just to identify the copyright holder. Is it the holding institution? Sometimes we'll see that donors transfer their rights to institutions, for instance. Our deed of gift said something like, to the extent that I hold these rights, I give them over to the university library, which is a really a little bit of a trick, right? It seems like you can't ever be quite comfortable that you have all of the rights. The example I like to give there is that if someone has correspondence that was written to them, then the writers of those letters actually hold all of the rights to them. And so you might actually have hundreds of rights holders in some collections. It just makes things a little bit more complicated. Many of our collections were really from an organization or an employer. There are often slightly different rules for that. Um, and just sometimes just pinning down who created the work in the first place is difficult. And you'll see information, I won't get down into the weeds of this today, but you'll see information on what we call orphan works, which might be a phrase that many of you know, of works that are ephemeral, maybe just have very little kind of provenance information. And so we have to kind of decide and make risk management kinds of decisions about whether or not to share without really knowing much at all about them. Um, the next piece is determining the copyright status to the extent that we can. And again, often we're working with larger collections. We can't necessarily look at everything item by item. But starting with where are you? Where will the work actually be scanned and shared? And often, as Stephanie and I have been talking about a little bit, that's kind of a combination of if you're outside the United States, then you're looking at the copyright laws of your particular jurisdiction. And then also considering to the extent that you can, the laws of the US where DLOC is actually hosted, and where we will be kind of on the hook as a staff if we're getting questions. And then, so it really can be kind of looking at both of those. And in turn, when we get questions from researchers or those who are publishing, I'm often saying, oh gosh, this person's publishing with Cambridge University Press and going and having to look at UK copyright law to make sure I'm giving them good advice on what to do with unpublished works in the UK, which have a whole framework of their own. Um, so there are also a couple of big differences, um, especially for 20th century materials, which of course are what many of us are dealing with day to day. Where in the US, the date of publication was very important. For the rest of the world in the 20th century, the date of the author's death was very important in determining the term of copyright. Now we see that much of that has been kind of smoothed out over time, that our laws are actually, because of international treaties, more and more kind of standardized. But because that doesn't necessarily apply retroactively, we see all kinds of variation in those earlier laws. But the third piece is really that evaluation of risk. And that's where I want very much to be a resource for all of you and for you all, because there's a lot of expertise in this room to be resources for one another. And a lot of that has to do, I was just saying to Rachel before the beginning of the discussion, a lot of that has to do with evaluating risk within your own institution and your own comfort level. I know what our risk threshold is at the University of Florida. I have an understanding of how likely it is that someone would object if we were going to share something online. But I certainly don't have a good understanding of the many different institutional and geographic contexts that everyone else is working in. And so I hope that you all will share with us, no, 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 I really can't share this here, or this is something that the lawyers at my institution or someone I've talked to has been concerned about. Or on the flip side, that our mission really says we need to be sharing this. It's really important for preservation, for global access to material. And I think as we make all of these copyright decisions, it's kind of unfortunately, it's rarely cut and dry that we really do have to go through that process of balancing mission against legal concerns or risks involved. And then finally, just the taking action piece, deciding whether you can do conservation and preservation, digitization, including whether or not you can share that material, um, outreach to your intended audience. And then I think very importantly for us, and something that I freely admit I often kind of fail to do at the end of a project, is sitting down and actually going through what was that workflow like? Can we document our decisions about copyright in this case so that we can apply them again down the road? Because you end up running into the same kinds of questions so many times when it comes to sharing your materials.